get started.
All right, so like she was saying, I'm Candice Gage. I'm the senior attorney at the International Institute. Been there over 2 years now. So I'm pretty comfortable with the work that we do in this community. And then Ebenezer PG is my coworker. He's a little bit newer, but he's been around plenty, over 6 months now, right?
Yep.
So just as involved as I am. He is here just to provide his own perspective. So if you have any questions directed specifically to my coworker, please feel free at any time during the presentation. But I'm just here to give you a bit of an overview on certain immigration issues that are probably going to come up and impact your work that you do through the CASA and GAL program, okay? And just so you know, I can make this available to whoever wants it afterwards. There are some links to resources throughout, so if you want a copy of it, let me know. I don't know who we can go through, but I'm happy to pass it around, okay? So like I said, there's gonna be 2 parts here. We'll take a break in the middle because it's some dense stuff that I go through at the beginning. But I just wanna go over some immigration law basics, kind of introduce you to what we do, and give you kind of a primer on the issues that we're gonna focus on later that I think you're gonna more likely see through your volunteer and your work with the juvenile court. So I'm going to start with the sources of immigration law, who impacts what's happening in our country, different immigration statuses you're going to see when you work with immigrant families, some of the issues that will come up when serving immigrant clients, and then just, again, some resources for your use going forward. So immigration law is not that simple. There are a number of different players, and the sources of law and regulations come from kind of all over the place. So our main source is under Article 1, Section 8, Clause 4 of the Constitution, which grants the federal legislative branch the power to establish a uniform rule of naturalization. Unfortunately, it is not that easy. The executive branch also has a lot of power to influence the laws and the regulations regarding immigration law or immigration policies in the US. And there's a number of executive administrative branches that also impact that work. The ones you're probably going to be most familiar with are the Department of Homeland Security, the Department of State, and the Department of Justice. The Department of Health and Human Services also gets involved, in particular when there are minor children, through the Office of Refugee Resettlement, I believe is the term, ORR, and also with unaccompanied minors. So there are quite a few executive branches involved, and depending on what you are doing, the type of benefits you are seeking, the status you are in will depend on which agencies you will have to deal with. And also, the states are quite involved as well. Even though they can't control immigration law or regulation, their actions can impact day-to-day living for any immigrant. In particular, most states will deny basic amenities other than emergency services, in particular to undocumented immigrants. For instance, oftentimes you'll hear people complain about undocumented immigrants being able to work and also get on benefits. This is not true. Most immigrants actually do not qualify for these benefits. That does fall under the purview of each state. In some states, they'll allow you to get a driver's license a little bit easier. In other states, they won't. So the states do have a pretty strong impact on day-to-day life for any immigrant in the US. Now, to find the law, there are 3 main places you'll look to. The first is the Immigration and Nationality Act. That's kind of your main source. That's where the bulk of what we do comes from. And then there's also Title 8 of the US Code, and then Title 8 of the federal regulations. So we have law. We also have a number of regulations that shift what the law means and what the law does. So it's constantly evolving as we go forward, especially with an administration like we have now, which often does executive orders that shift what it means to come to this country seeking asylum or be in this country undocumented. It's constantly evolving, so it can be very hard to keep up. And basically for the juvenile court, what I want to highlight is that even though state courts cannot make immigration decisions, their actions and decisions can still impact an immigrant family, an immigrant individual. So it's not as if they have no power at all, okay? So some of the statuses you're going to come across. First and foremost is your naturalized US citizen. There are two ways of getting citizenship if not born to a US citizen parent or not born in the US. The first way is through naturalizing. You have to, I kind of put it all up there. There are a number of different requirements that you have to meet before you can naturalize. As I list, you have to be over 18. You have to be lawfully admitted as a permanent resident. You have to have 5 years of continuous residence in the United States, 3 if you came here on a visa through your spouse and are still married to them. And you have to have good moral character and be willing to take our oath of allegiance. So there's quite a few requirements. It's actually not that simple to naturalize. Yes?
Can you expand on good moral character?
Mm-hmm. So,
I'm curious how that's, yes, if you could just expand on
What are the criteria?
the criteria and how that's determined.
yeah. So it's actually quite vague.
Okay.
There's no clear definition of what it means to have good moral character. There are a number of different things the government will look at. First and foremost, do you have any kind of criminal record? For permanent residents seeking to naturalize, there are 2 big issues you're looking at. One, does a crime make them deportable, which is its own separate issue and a bigger issue than just whether you can naturalize. And then this other, which is good moral character. Do you have the qualities to be a US citizen? So even if you commit a crime, for instance, DUIs, OVIs here, if you have so many on your record, you're kind of in this weird zone where you haven't committed a crime bad enough to get you deported, but you might not have the right character to be a US citizen. Now it seems a bit weird because plenty of US citizens commit DUIs all the time, but the government has created a system in which we believe you have to meet a certain standard to become a US citizen. And so they list out a bunch of things that say, well, if you do this, you definitely can't be a US citizen. But there's a lot that they don't actually explain. And so you answer a number of questions when filing the form, and they have to do with your immigration history, your criminal history, if you've ever been an alcoholic, a bunch of weird topics, and then even questions on whether you were ever part of Nazi Germany in the 30s to 40s. So there's a lot of weird topics that they cover, and depending on how many you say yes to will depend on whether you qualify based on your good moral character. So it's really not a simple, okay, you haven't done any of these things, so you're good. It's more, if you've done something, how can we still say, well, even though you did this bad thing, you're still a good person, you still deserve to be here as a citizen. So it's not that simple, but for the vast majority of our clients that come through the International Institute, the good moral character is not a main concern. But unfortunately, it does come up with even simple crimes like a DUI. We'll have to go through their history, make sure there's some good qualities that overcome having that on your record, because especially in this day and age, it could cause concerns for naturalizing. And then there are also some crimes that mean you will never naturalize. You will never be eligible to. That can actually include things like falsifying documents if you had a weird immigration history. Could mean lying to US officials to get in. Could mean if you registered to vote is a big one. A lot of states have not great systems for registering to vote. A lot of for instance in Ohio, a lot of the agencies like the Department of Jobs and Family Services, the BMV, they have to provide a voter registration card, but for seeking certain benefits, but they don't actually explain to permanent residents that they don't qualify. So oftentimes a permanent resident, especially if they have a language barrier, won't understand that it's not something they should be signing, not something that they should be doing at all, but no one's explaining that to them. So they can get them into a lot of trouble if they accidentally registered to vote when they shouldn't have. So things of this nature can sometimes permanently bar you from being a citizen, beyond maybe having bigger issues of making you deportable from the country. Okay? Yeah.
They usually get, if so, let's say somebody registers to vote who shouldn't have,
Yeah.
then they go to a polling place to vote. Is it virtually certain that they that would be caught?
No, in fact, I've had it. I'm actually working on a case where this happened. She was seeking Medicaid for her children. The application to register to vote was included in the packet. She filled it out, assuming she had to get the benefits for her child. And in a contested state like Ohio, as soon as you registered to vote, you get tons and tons and tons of things in the mail telling you, go to vote for this person, go to vote for that person. It's your duty. And so she was given bad advice and was told that she had to, now that she was registered to vote, that it was her duty as a permanent resident in the US. She voted once, and no one caught it. So on her record, even though it will say not eligible, even though she's registered as a not eligible voter, she was still eligible, or she was still able to go in and vote at her polling place on that day. So as much as we have these laws in some ways in place to protect voters, they can sometimes be harmful towards not citizens, so permanent residents and other immigrants in our country. And it can cause a lot of concerns because you can be deported back to a country. Even if you were a refugee originally, you were fleeing violence from your country, voting is a very big crime to the US government and can cause a lot of concerns. And there is no guarantee that you will be able to get out of the deportation. So.
Follow-up question, how are they likely, would that likely show up that they did it illegally?
Oftentimes it actually is through an application like naturalization. You submit your application, like I said, they go through a lot of weird questions, and USCIS will, US Citizenship Immigration Services, under the Department of Homeland Security, their job is to dig into your history. They do background checks, they look through your immigration history to try to find these things to either place you into removal or deportation proceedings, deny you a benefit. So oftentimes it's just seeking out a simple benefit from them, and it brings it up to their radar, and then you're placed into proceedings directly from there. So it's definitely a big issue. In particular, the voting, I've noticed, having worked here, it comes up quite a bit. And I think it's because in Ohio, with the way that we've set up registration, it's important because you want voters to get registered, but there's not enough informed polling or registration places that inform people that they can't actually register. And that even if they say, no, I'm not a US citizen, by signing that voter registration card, there's a nice little line on it that says you are now claiming that you are a US citizen, regardless of what you answered to the questions. So yeah, it's not, it can be very dangerous and a hard issue to get past if you were just misinformed. So that's naturalized US citizens. Oh, sorry. Deriving citizenship is the other option we usually see. And that's, let's say you had a refugee family come to the US. They've been here 5 years, so you have children who are still under 18, and then parents who are ready to naturalize. If those parents naturalize, then the child can derive that same citizenship benefit through their parents because they are not eligible themselves to naturalize. Yes.
But it doesn't happen organically at the same time. So when the parents are naturalized, are the children automatically naturalized?
Technically by law, automatic citizenship.
Okay.
However, there's no proof of it. So you have to kind of bend over backwards to prove it. And you can do it one of two ways. You can seek a certificate of citizenship, is what it's called, for the child. You just submit some documents proving the relationship, proving the parent naturalized, show that they live together and a bunch of other random things. And then you'll go to the USCIS office. It's up in Cleveland, US Citizenship and Immigration Services. They'll ask you some questions, and then they can give you your citizenship certificate that same day. For others, you can actually just apply for the passport itself, which is a lot cheaper. It's over $1,000 to get the certificate of citizenship for children, whereas passport is still only $160, $170. You actually have to prove the same stuff. You have to show parent is a citizen, child is related to the parent, they were a green card holder at the time that the parent became a citizen, but you can actually do that through applying for a passport. It's a little bit more complicated. It's not your typical passport application, but you can do that. And then it's proof. It's always safer to have that certificate of citizenship, but we definitely have families who cannot afford to do that. And I'll talk about this later, and these prices are going to increase going forward. They usually do every few years, so it can be incredibly difficult to access these benefits. Which brings me to lawful permanent residents, or often called green card holders. They're another large subset of immigrants in our community. These are people who are allowed to reside and work permanently in the US, but they do not have the same protections as a US citizen. There's still many things that can cause problems for their immigration status. Again, we return to if they do sometimes even minor crimes, it can cause significant problems for the immigration status. As I've listed here, certain criminal offenses, abandonment of your green card, so if you stay out of the country a little bit too long, even though you intend to come back, it can still cause problems. The voting issue comes up again, and now a bigger issue is becoming a public charge. We'll get into that in more detail a little bit later. So some that you're likely to come across working within the juvenile court, there is what's called a special immigrant juvenile. That is something you have to seek through the juvenile court system, and then you can seek benefits from it through immigration services later. This is for children who usually only have one parent or no parents in their life. Oftentimes, the parent that is missing or both parents abused, neglected, or abandoned the child for some reason. And now they're here in the US seeking help through the juvenile court. And then if they are determined to be in need of those services, they can then seek immigration status through USCIS. So it's a little bit complicated. We'll get into more details later. And then you'll also see, especially in our community, a lot of refugees and asylees. That's because our office, and we were actually talking about earlier, World Relief, we're big refugee resettlement agencies. So we resettle into our community. So you're very likely to come across a lot of refugees. Even though the numbers are decreasing going forward, they're still pretty consistent through our office, so you're definitely going to come across. Asylees are very similar, but a little bit different. Asylees, they are fleeing their country for the same reasons as refugees, but they come to the US first to seek that status, whereas refugees, have to be afforded that status outside of the US first. Again, with anyone who's not a US citizen, you can still lose that status for a number of different reasons. So it's not great for them to remain in that status when they can adjust to something else. Okay. Now we're getting into some stranger types of immigrants. Definitely people you're going to come across, but not as frequently. So there's a huge subsect of immigrants, because of how vulnerable the population is, that will be victims of certain crimes. Usually they fall into three camps. One is VAWA self-petitioners. VAWA is the Violence Against Women's Act. So often these are people who are in abusive relationships, often with US citizens. So they might not have status. They might be legal permanent residents. Doesn't really matter what status they are. If they're a victim of domestic violence, they are afforded certain rights under immigration laws. You can also be the victim or witness of a crime that would afford you a U visa. You have to be willing to aid in the investigation of the crime. So it's a very strange type of status that you can have. But the U visa also leads to permanent residency down the road. There's a long wait time if you are granted the U visa to get the permanent residency, but it is a pathway to legal status here in the US. And then there's victims of trafficking. Victims of trafficking often are minors because undocumented or migrant children are often very susceptible to trafficking issues. So you might actually come across this more frequently than you'd think. And then we have the subsect of lawful non-immigrants. This could be a number of different groups. It could be your B1, B2 visitors. It could be students here on temporary visas studying. Certain business visa holders where they're working with certain companies or organizations in the US to get more experience before they go home. There are temporary protected status visas, usually from a country that's experiencing some kind of natural disaster. They're afforded the right to stay here for only a short period of time, depending on the status they're seeking. And all of these types of non-immigrants may or may not be eligible to adjust their status to a lawful permanent resident, depending on how they arrived, what type of visa they're still in, and how they're able to adjust. So lots of different issues there. And then the last group of immigrants that you're gonna need to understand their issues that they have to deal with are undocumented immigrants. This can be an entire family, this can be just children, this could be just adults. Undocumented immigrants are not necessarily barred from adjusting status or for seeking certain benefits, but it can be a harder pathway. But don't just assume that if someone is undocumented, they will have to remain that way. It's very important when you're working with undocumented immigrants, if they are not already speaking with an immigration attorney, that's usually the first resource you want to connect them with. Make sure they're talking to someone to see if they have options, to see how they can pursue those options, see if they have any relief from deportation, if they're in removal or deportation proceedings. It's very important that they get connected with an immigration attorney, because oftentimes that's their main source of instability and vulnerability, is the fact that they are still undocumented. Some of the possible forms of relief, which we went over before, the Special Immigrant Juvenile Status, the VAWA Act, or Violence Against Women Act, U visas, trafficking visas, asylum. So all the ones that I mentioned before, they could be eligible for them. So it's important that they talk to somebody to see what options are still available. And just so you know, a lot of these options can be terminated or changed simply by the president's executive order. In particular, one that you might be familiar with is Deferred Action for Childhood Arrivals, or DACA. Some people call them dreamers. The term dreamers actually came from the DREAM Act, which never passed Congress, which was a more permanent solution for these individuals. DACA is temporary, it's through executive order only. And I don't know if anyone is familiar with it, but Trump did try to get rid of this program when he first came into office. It was unsuccessful for now, but it does not mean that he would not try again. So a lot of these options are not necessarily going to exist forever. So that's why it's very important to connect with an immigration attorney, because if there's a timeline that you're on and you have to get something in now before it goes away forever, you don't want to lose out on that option.
You work with many DACA?
Yeah, I actually get quite a few. It's usually DACA recipients that have already received it before and now they're renewing. It's hard to get new DACA recipients, and in fact, the one successful bit that Trump was able to do was block any new recipients who have to apply for the first time. They are not allowed to apply right now. So you have to be renewing, otherwise you kind of don't have access to that. Because the time frame that you're looking at here is they arrived prior to 2012. So a lot of these individuals, as a child, a lot of these individuals are actually adults now. It's not new childhood arrivals. And it's, for some of these individuals, the only option they have to at least remain in the country that they've known since they're 2-3 years old, while trying to seek out a more permanent status here.
When they go to renew, is there ever danger of deportation at that point?
Yes. So again, especially with criminal backgrounds, DACA recipients can be thrown out of the program if they commit certain crimes or if they commit multiple misdemeanors. I think you have up to 3. If you commit more than 3 misdemeanors, then you could be kicked off of Deferred Action for Childhood Arrivals. Thankfully, and I'll talk about this a little bit later with delinquency issues, most juvenile records do not impact your immigration status, but still something to be aware of. There's that, and again, with the instability of the program itself, we never know when the rug is going to be pulled out from under our feet. Like I said, the courts stopped it for now, but that's not necessarily going to stop them forever.
How does a juvenile record of you impact the parents?
Mm-hmm.
A refugee or
So the main issue, especially with, so I'm going to look at the undocumented immigrant family rather than someone who has status. If a child is facing delinquency issues, to me, the first hurdle they have is getting access to resources that can help that child. They don't, like I said, aren't guaranteed any kind of benefit. So it might be, how can I afford behavioral therapy for that child? Can I even access a doctor to do that? Another big issue is if you have to go to juvenile court. Right now, there's been a huge push for Immigration Customs Enforcement, ICE police, to attend like local courts to pick up somebody that they've been looking for to put them into removal and deportation proceedings. That is usually targeting the parents, but if a parent has to attend a juvenile court proceeding, it's possible ICE will be there waiting for them to finish and then grab the parent and go. And especially with increased, and I'll get into this a little in more detail later, with increased detention, with increased enforcement actions, that is a huge concern for us right now. I had a different family that I was working with the family was just trying to get the daughter into some therapy because she experienced pretty horrific trauma at the hands of some individuals in her home country. And they were not able to access those, get to the doctor and go to any kind of counseling because ICE kept coming to their door and they were too scared to leave their house. So now you're seeing the juvenile harmed, even if it's not ICE action against the juvenile, because the parents are being targeted. So that's the first hurdle. In addition, I don't think necessarily this would come up, but if the juvenile is ever having issues that could have nothing to do with the parent, could have something to do with the trauma they've experienced in their home country, the trauma of having to travel from their home country to the US. If there's ever a custody issue, you would not want to have, and again, we'll get into this a little bit more, the parents' immigration status, or their worry about their immigration status, or trying to protect their child through these issues to impact whether they can keep their child. So we're gonna get into all of this in a little bit more detail in a bit, but it's a little bit less focused on the direct impact on the parents' immigration status, more so than like tangential issues that could impact it later. So, all right. So then I wanted to cover a couple of things. I think you talked a little bit about serving clients, especially from like a mental health standpoint, I believe, earlier. But some of the things that I wanted to go through are issue spotting with immigrant families, trying to figure out what's the biggest causes of concerns for them and whether you can connect them to the right resources. Language access, which is always huge, making sure that they understand any process that they're going through, making sure they understand their rights, their responsibilities, and then cultural awareness. So I'm just going to touch on this lightly. If anyone has any questions, please feel free to ask. First and foremost, issue spotting. You're definitely, especially with undocumented individuals, you're definitely going to be seeing a lot of impact from a variety of different places. If they're undocumented, they're going to have a lot of stress and anxiety about that. And that's going to impact their trust and willingness to engage with you as a direct service provider, to engage with new service providers that you're trying to connect them to. And let's say you're in court, sometimes it impacts how they're responding to a judge or to questioning. So it's something that you should be aware of, and you might need to not only get in touch with an immigration attorney, but maybe mental health professionals who can try to take care of some of the PTSD they might be dealing with, the trauma issues that they're dealing with. In addition, especially with unaccompanied juveniles, so a minor who does not have any parents, maybe no family at all, they're very vulnerable and susceptible to trafficking, to crime, either being targeted to commit it, usually in their home countries by gangs, or once they get here, just being harmed by bad actors, and they're vulnerable to other abuses that can happen just by being an immigrant in this country. So it's definitely important to be aware of things that might come up in conversations or working with them that might make you pause and go, something more is going on here. Maybe you were harmed by a parent and I had no idea, and now I need to connect you to the right resources. So it's always important to be aware that there is a lot going on for a lot of individuals. Even if they have status, there's probably a lot going on. For instance, with refugees, a lot of them do have PTSD. They do have other mental health concerns. Maybe they're illiterate from their country, and that's going to impact how you're working with them. So it's just very important to be aware of all these issues. And if you're sensing something more is going on, try to connect them to the right resources, okay? Kind of tied to that is language access. In particular with court proceedings, most courts actually are required to provide interpretation, definitely in court, but even when working with the court at all. And that's because anyone who receives federal financial assistance is required under federal law, under Title, 6, they're prohibited from discriminating based on a number of different reasons, and national origin has been expanded to include language access. So it's always important to make sure that your client is being afforded that right, and that they understand whatever you're working with them on, what is happening, what their rights are, what their responsibilities are, and that they're understanding in their own language, okay? And lastly, cultural awareness. Again, this kind of ties into everything. Just understand, especially if you're CASA or GAL, that you might encounter different cultures, different views, different parenting styles. Doesn't necessarily mean that it is harmful to the child. And sometimes we have our own internal biases that we have to overcome just to understand that something that's different doesn't make it bad, but also if it is bad, you have to address it. So just something that I think we all struggle with when we encounter things that we are not familiar with. Okay? And then we're gonna get into some resources here. Your 2 local immigration nonprofits that have offices in Akron are International Institute. We are right up here in the St. Thomas building. That's our main line. And then Asia Inc. also has an Akron office. There are plenty of other nonprofits in Ohio, so don't think these are the only 2. It's just if you're working in Akron, these are the closest. Then there's also a lot of providers that are nonprofits that aren't doing specifically immigration work, like Community Legal Aid. We had talked about World Relief earlier. They were another refugee resettlement agency. The Akron office was closed when refugee numbers went down and funding went down. Their funding was cut, so their office is no longer open. I'm not sure if the Cleveland office is open, so I'd have to look that up. But there are definitely a lot of nonprofits. There's a great network in Ohio. We're small but mighty. So if you're looking for Akron, start there, and we can always connect you with someone else if we're not the person to go to. If you're up in Cleveland, there's Catholic Charities, Abel's in Dayton, Toledo, I think maybe Columbus, but I don't know that for a fact. So there's a lot of us around. I would definitely start there if you're looking for immigration help, but don't forget that nonprofits usually have a lot of connections with other resource providers or service providers that could be very useful to you. Okay? And then again, I will pass this around, but here are some websites that I would send you to just for some help in working with juveniles, and in particular, immigrant juveniles. So there's the Handbook for State Public Benefits for Refugees. Again, most other immigrants in our country, in our state, are not afforded benefits, but some, like refugees, are, and that'll kind of help you through that. We have at the top some resources that were put together by some other national nonprofits about how to work with juvenile immigrants, particularly in the juvenile court context. So these could be very useful to you. Just try to take a look later. All right. So we're going to get into the more dense topic now. There have been a number of executive orders since the new administration. Yes?
Just before we shift gears, can we just do a plug for the immigration clinic at the University of Akron? Dr. Knowles' work. Because I don't think a lot of people in the community realize what a fantastic resource that is.
Yes, please. Please. I wasn't sure if there's anything else. So yeah, there's also a number of clinics. She was specifically referring to the University of Akron Law School's clinic. Professor Knowles, a great colleague of ours, she was doing a lot of work out at the Northeast Ohio Correctional Center, which we were also working with. They do a lot of great work. We actually refer to them when we can't take a case in the hopes that they would be able to if they have the room. There's also a clinic up at Case Western. I think they do trafficking cases as well as a number of other types of immigration cases. So clinics are very important, and we have a lot of law schools near us. So you can always try to tap into the law schools to see if they're taking cases through their various clinics. But
They do put on professional development workshops that are open to the public occasionally.
Yeah.
That are tremendously helpful.
Yeah. Fantastic. Definitely another resource to tap into. Professor Knowles is excellent. Farhad Setna, who's actually a private immigration attorney out of the Falls, he also works with the school as an adjunct professor. He's another one of our colleagues, so he's also a great resource.
I can get your shout out.
Sure. The University of Akron, their law school has, they have several clinics where students in the law school get some practical experience. And one of the ones that they have that I think is really doing amazing work is they're doing an immigration clinic. So the students are representing people who are applying to live in the United States under the supervision of a professor, Elizabeth Knowles. And so one of the things that means we get more people with practical immigration law experience in the region and in the state. but it also means that locally it's a resource for people coming into Akron and Cleveland to get the kind of representation that ordinarily lots of people who are called into court do not have any representation at all. And so they're able to have representation through these law students and professionals. And they also will do professional development type workshops similar to this around immigration law and the things that they're doing in the clinic that are open to the public. So they do symposia, and they just do other 3-hour workshops, and it's really very interesting and helpful to go and kind of take a listen as to what they're up to.
Yeah.
You're welcome.
Yeah, they're definitely excellent. And like I said, we often refer our cases to them because it can be hard in this environment with, as much as I say there are a lot of us nonprofits, we are still only 2 attorneys out of International Institute, and it's often very similar to a lot of other nonprofits. So we do also rely heavily on the clinics. We try to collaborate on a lot of things to make sure we are providing as much representation for people who require it. So thank you. All right, so executive orders. I'm gonna go through the 3 biggest ones. They're in kind of give where they started and where they're at now. Just so you know, a lot of these executive orders are still being fought in courts. So things are gonna be changing as we go forward. They're changing all of the time. If you have any questions, I will do my best to let you know how it's proceeding. So the 3 that I'm gonna go over, the first was Executive Order 13769, which was issued January 27, 2017, right after Trump took office. And it was later superseded in March by a very similar executive order. It was called Protecting the Nation from Foreign Terrorist Entry into the United States, more commonly known as the Muslim ban or the travel ban. This is not the first travel ban that was ever ordered by a president, but it was quite broad in the countries it covered, and many people feared that it was focusing on Muslim majority countries, and we were worried that this was an attack on those individuals in particular. Subsequent presidential proclamations have changed that list that is affected. In fact, a new proclamation just came out in December, so the list has definitely changed. A couple of countries have been taken off of it, but it's more adding countries to the list at this point. So we'll get into the details in a little bit. And then there was 2 issued on January 25th. One was enhancing public safety in the interior of the United States, and then border security and immigration enforcement improvements. I did add those secondary quotations in there. So as I was mentioning, the travel ban, the initial effects was the 90-day ban on 7 countries, the 120-day halt of the refugee program entirely, a complete ban going forward indefinitely on Syrian refugees, prioritizing minority religion claims. This actually tended to be Christian claims in majority Muslim countries, is what that was. And then the refugee number was the ceiling for the number of refugees we let in a given year, went from 110,000 to 50,000. That number has continuously decreased each year Trump has been in office. The subsequent changes, as I mentioned, there have been other proclamations that have changed the list. Most recently, what was it? North Korea was added, Burma, or Myanmar, Nigeria, there's Eritrea, and like 1 or 2 others, to the list that already exists. Those have not changed. Now, each country, it's not necessarily a total ban on visas, and it's not necessarily a ban on the refugees coming from these countries. To get specifics, you can actually go on the Department of State's website, and they have to put a list up of what countries are being banned and for what visas. There are some countries that are banning all types of visas. That's immigrant, non-immigrant, doesn't matter. What that means is that you can still apply for these visas. It's not, a total ban doesn't mean there's no options, but it's much harder to get the visa, and now you have to give the consulate or the embassy a reason why they should be granted, even though there is a ban on the visa in place. So it's a little bit difficult. In particular for our clients, there are a lot of Burmese refugees in our area. We're still receiving Burmese refugees, so applying for their family to come and live with them now, if they were separated during the refugee process, has become a lot more difficult, especially with these bans in place. So so you know, this was fought in the courts for quite a long time. Supreme Court did uphold the third iteration of the travel ban, meaning it was allowed to go forward as it's still being fought in courts. But there was also a lawsuit specifically about certain families that were impacted by the travel ban when it first went into place. That actually, there was an agreement between the government and these individuals, which now prioritizes the processing of dozens of these refugee cases affecting those individuals in the US. So it's kind of weird, it's like two different tracks. One was broadly the entire travel ban, and the other was specifically those individuals who were impacted by the travel ban. The second one, the enhancing public safety. The effects were changed enforcement priorities, including language as has been convicted, have been charged, have committed acts that constitute a chargeable offense, in fact, including fraud and public benefits receipt. It authorizes state and local law enforcement officials to perform the functions of immigration officers for apprehension, detention, investigation, and as many people may have been hearing about, revoked federal funding to sanctuary cities. Sanctuary cities is this weird term that's regarding areas, local areas usually, that have refused to cooperate in the way that they're expected to with ICE officers. Oftentimes what that looks like is ICE will put a holder on a person who's been put in jail, even for something pretty minor, so that they have to go into ICE detention immediately after. Some cities say, that's not our job. We don't have to comply with that. We're not going to comply with that. So, of course, our administration says that this is causing significant harm and impacts their enforcement priorities. And so now they're trying to revoke federal funding to those cities. This has not been successful so far. All of this is still being fought in the courts. And in particular, I think the issues that are important for you guys to know about for this, this particular executive order, the deportation, detention, and local enforcement issues. So for deportation, even for juveniles, if you are in, or if you're being processed from having arrived undocumented, the court proceedings are going to go faster. You're going to get pushed through the system. You're going to have less time to seek relief or benefits that you are afforded under our laws. And it often can mean that you will be detained when you otherwise would not have been. There is a huge issue because there was the Flores settlement that talked a lot about whether you can detain juveniles in these immigration detention centers. A lot has shifted with the whole separation at the border. It's still continuously changing. It's never really been good for the immigrant juvenile or their family. So this is still evolving. It's still something that you're going to be seeing. It's not as much in the news anymore, but it is still an issue that we are dealing with. Then detention issues, as I mentioned. Do our local law enforcement work well with ICE or not? I will say Akron doesn't seem to be too bad. They do like having a strong connection to our community, and they understand we have a very large immigrant community. However, I do know that detainers do work in this state, so oftentimes people will be held over until ICE picks them up, just so you know. And then again, this executive order authorized local law enforcement to act as immigration police, essentially. A lot of local law enforcement don't want to be doing this. It harms their relationship with their community. This is not something that they should be doing. And many advocates still maintain that this is better served by immigration judges rather than local law enforcement, who might not be as well informed and who aren't able to provide the same informed discussion that an immigration judge could when you're in court explaining what your rights are as an immigrant and what you can apply for. So these are things that are going to come up. They're not as big right now, but it's still an executive order that is in place, still being fought in the courts, but still able to go forward. And then the last one was the border security. This was the wall executive order. It directed Homeland Security to allocate funds to the construction of a border wall, expanded the use of detention at the border and in the interior, expanded detention capacity, meaning more jails for immigrants, expanded expedited removal, which is very fast processing of immigrants who recently arrived, meaning they can be deported almost immediately without necessarily being afforded their right in court to seek asylum or other relief. And again, allow local and state law enforcement to perform functions of immigration agents. And again, same kind of issues here. And it also allowed the immigration courts to conduct removal proceedings outside of the US, which is very strange and very harmful because it's very difficult to get any kind of representation, especially useful representation, when you can't even access anyone in the country. And a lot of attorneys who are trying to get to these immigration courts and detention centers not in the US are having difficulties accessing those clients. So again, issues to look out for, especially with juveniles. They're gonna, like I said before, face stricter timelines. Risk of deportation will be higher. Risk of detention is gonna be higher. Especially if they've arrived within 2 years, they could be placed in that expedited removal. It's not good, means again, they might not get their day in court, in immigration court. And then if you come across, this is again, looking out for issues so you can connect the UAC or the unaccompanied child to the right resources. If you suspect that they have been present for less than 2 years, please refer them to an immigration attorney to see what relief they can still seek. Okay, got through the executive orders. There's also a couple of other issues that are really big in the news right now. I kind of put them here. If you have specific questions, we can go through them, but there's a lot to unpack in these 4 little bullet points. Some that you might have heard of or should be familiar with is the migrant protection protocols. This was the Remain in Mexico policy. This allowed the US to hold people in Mexico, if they were not from Mexico, while they were trying to seek asylum and flee from violence, which is not good because a lot of the people they were fleeing from also have control over places in Mexico. And again, it places these immigrants in a very vulnerable position where they could be trafficked, they could be victims of crimes, and this is not just for adults. This is children. This is families. So not a good policy at all. Still going forward, being fought in the courts. There's also the third country transit bar, essentially stating that if you are coming from certain Central American countries or elsewhere and have traveled through countries that you should have stopped in to apply for asylum and you did not, we are refusing you that right here in the US. Again, very problematic, very controversial. Question of whether that's even okay under international law, the treaties that we have signed on to. So that is also being fought in the courts. And then 2 that impact even people who are already lawful permanent residents, who may be seeking other benefits from the government. It's the public charge rules and then proposed increases in immigration form fees. As I mentioned earlier, fees are already incredibly high. Fees do get increased, as many fees do, but the fee increases right now are like, was it like 80-some%, 70-some% for some of these forms? So you're almost doubling the cost for some of these benefits. And if you can imagine, most people can't afford some benefits already. Go ahead.
I remember reading just like 3 or 4 days ago that a judge had said the protection protocols were illegal and they were stopped, and then the Attorney General challenged that immediately. And just hours later, it was reversed again. Can you tell us where that is right now?
Yeah, so these are really difficult right now because things are constantly changing day to day. And depending on what court and what level they were at and how they determine whether there should be the challenge. As far as I understand, please correct me if I'm wrong, Ebenezer, the migrant protection protocols do not have an injunction on them, which means even though they're being fought in the courts, the government can still go forward. They can still be doing this while they're fighting it out and making a determination on whether they can or cannot. So as far as I'm aware, maybe this has changed recently, this is still in effect. This is still something that they can do while we determine whether it's fair or not. But am I correct with that? Okay, because I don't think there was an injunction. I think there was initially, and then it was overturned or something. It's hard to keep track of all of them. A lot of these have been under an injunction at some point. But then that injunction will be overruled as overbroad, stating that it should be allowed in certain areas, or if a state court determined that it was not fair for all states to have an injunction on it. It's very complicated, but as far as I'm aware, this is still something they can act on, even though it is still being fought in the courts. Okay. And then public charge, quick note on that. This is something that we've always dealt with, and it's in particular it's for people who are trying to adjust their status to permanent resident. You always had to prove that you were not going to be a public charge. However, this has increased what they look at, which could cause you to be a public charge or make the government fear that you will be a public charge. In particular, it covers a lot of benefits that people might seek at any given point. Thankfully, the vast majority of people who actually qualify for public benefits in the US are exempt from this rule. So if you're a victim of a crime, if you're an asylee, a refugee, these do not impact you. But it is something to be aware of going forward. If you have a family where maybe they want to apply for somebody, petition for somebody, this is something that could be impacting that ability. Okay? All right, so we got through all of the dense stuff. I figured we'd break for like 5 minutes, and then we're going to talk about some custody and delinquency issues for juveniles, which I think is going to have a more direct impact on the work that you would do. All right. And also, just to explain to people, didn't really explain this, the immigration court process is a weird one. So immigration judges don't have true independence. Immigration judges aren't even true judges, they aren't even true administrative judges. The immigration court system, or the Executive Office of Immigration Review, falls under the Department of Justice. So you have the Department of Justice ordering a decision in your case, and you have the Department of Homeland Security ordering or requesting that you be removed from the country, because they are the government attorneys that we go against. And then there is usually a private or nonprofit attorney, if the individual is lucky enough to have one who's fighting on their behalf. But it's the government and the government. It's just a guise. Any independence in the court system is just a guise. And especially what we've heard from the immigration judge union is a lot of judges are not happy about this. They want the independence, but they don't have it. They're kind of under the Attorney General's thumb. And especially with this kind of administration where they're using that as power to affect the immigration system, we can see how it can really be twisted against individuals. So just something for everyone to be aware of. As much as you might see things work differently in juvenile court or other local state courts, it's definitely not how it works in the immigration system. And as I mentioned, despite the heavy consequences for some immigration proceedings, immigrants are not afforded the right to an attorney. They have to either find one or pay for it out of pocket if they're able to. But again, with the increased detention, with people being held in Mexico, with people not being allowed to even get into the country to apply for asylum, it can be very, very, very difficult to seek representation in the system. Okay? All right, so we're going to try to get into some custody and delinquency issues. These are issues that are going to be particular to the juvenile court setting. Please feel free to ask me questions again at any time. So first and foremost, we're going to go through a couple of different issues here. We're going to be talking about why maybe refugees and unaccompanied minors might not have parents or guardians with them. In particular, if you're doing custody cases or guardianship cases, how do you do proper service in foreign countries? What your immigration status, what the impact should be on these cases, especially if you're considering the best interests of the child. And then we're going to get into a little bit more detail about special immigrant juvenile status. I kind of alluded to it earlier, but we're going to get in depth with it, explain a little bit more of why we have it, what its use is for immigrant children, and when it's appropriate. So, custody issues for refugee cases. It's not uncommon for refugee children to be separated from their parents. Could be because of the conflict that they are fleeing from. It's not uncommon that families will be separated just through that process of fleeing. Maybe the parents were harmed or killed in some way. It could be that the parents have been out of the life for so long that the child actually views the aunt or the uncle as the parent. It has no idea that they're not the parent. So we definitely see these issues come up quite a bit. Usually I think we get a couple of cases a year through our office with refugee resettlement. So it's not like every family coming, but it's definitely something that we frequently see. So before arriving in the US, UNHCR, or the United Nations High Commissioner for Refugees, who is overseeing a lot of what happens overseas before someone's resettled here in the US, they do make a preliminary determination of custody. So UNHCR and IOM interview the refugee child, potential guardian, and the biological parents, if still available, family, community members, in making preliminary custody determinations. They use what's called a best interest determination report. It is something that the Refugee Resettlement Agency will always have a copy of. Again, I'll pass this around, but if you go to the link that I have here, you can see a number of these different charts and used in a number of different situations by UNHCR, just so you can get a little bit familiar with it. So refugee resettlement agencies have to ensure legal custody is done correctly within the first 90 days of the child arriving. So it is something that we will work on almost immediately when the child is resettled here. And again, this is very important because, as I mentioned before, juveniles are very susceptible to trafficking and other abuses. So if we can make sure that custody is with the proper adult, maybe a family member, then we know the child is going to be in a much safer position going forward. And again, as I mentioned, the child would always have the best interest determination report. This is a great place to start if you're working on one of these cases. They're always issued, at least in our office, probably very standard for all refugee resettlement agencies. We always get a copy of it. So if you're working on these cases and you want to see the report, which you should, you can start by reaching out to that refugee resettlement agency. Okay. Now, another issue that usually comes up is if the parent, which you have to provide service to about custody issues, custody cases is not in the US, but in a foreign country. How do you perfect service? This is more in the case for the attorney, maybe not so much if you're a social worker or another volunteer, but there are definitely rules that apply. I've listed them here. We don't really have to get into details. You'll be getting a copy of this, so if this is something that applies to your work with custody cases, please take a look at these rules. But there's a number of rules that do apply. The Ohio Rule of Civil Procedure 4.5, if the country is a signatory to the Hague Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters, that link has all the signatories listed. And then 4.5b, if the country is not a signatory. Practical solutions, I've listed out what you can do. It might be a commercial carrier service, it might be a private process server, really just depends. And then ultimately you do have a waiver of service if required. Again, just be familiar, if you are doing this work, be familiar with the rules. And then what I think is really most important about service is you do not have to perfect service before you can file, at least for temporary custody. Because again, the main issue here is whether the child is in a safe and stable environment. So you may be filing for temporary custody while you're still trying to perfect service on the family members who are not here. So as I've put here a little timeline, I would file a complaint with the motion for temporary custody. You're gonna have a hearing on that motion for temporary custody. You're gonna be attempting service. We will eventually perfect service, but things can be going on before you do that. It can take time when working with foreign countries, so just know that there are other options while you are waiting. All right. So I have a hypothetical here. This is to see what people think about immigration status and its effect on custody cases. Obviously, a lot of the job of a CASA or GAL, CASA volunteer or GAL, is whether a certain situation is in the best interest of the child. So my question is, if their parents A and B are not married, both are seeking custody of child C, 10-year-old Mexican girl who is currently undocumented, and parent A is a US citizen while parent B is currently undocumented, who should receive custody?
In our courts,
If you're seeking custody in juvenile court.
in America.
Mm-hmm.
So don't our citizens get priority in our home courts or not?
I can answer that in a minute, but is that your answer? The US citizen? Don't know enough? Okay. Don't know enough? So this is a trick question, sorry.
Outside of it, I was saying not the best interest standard, but what the legal standard.
So actually, legal standard, immigration status does not really play a role, at least, well, this is the best interest of the child, but also undocumented immigrants can be granted custody. So it doesn't keep you from being granted custody in our courts. So a little bit of a trick question. We don't know, we do need more information. It really just depends on the situation with both parents, but just because you are undocumented here does not mean that is permanent, does not mean that you might not be adjusting. And so, yeah, it was a trick question, I'm sorry about that. It really just depends, and again, our laws do not require that somebody have status to be granted custody. So just something to keep in mind.
So in many countries, a citizen parent would have priority over a non-citizen parent. Not necessarily, it wouldn't be dispositive of the issue.
Right.
Is that the case here, that a citizen parent has an edge over a non-citizen parent, or is it completely disregarded?
So when it comes to the law, for the best interest of the child, so the priorities, immigration status is not actually listed. It's a number of other things, stability of the household, any abuse, all that type of stuff, but immigration status is not listed. So it's not necessarily dispositive. It might be something that judges will consider. And I'm not saying that they won't, but it is not something that should be the end-all be-all for the court to consider. And in particular, as we'll go through, it's very possible that the U.S. citizen parent might be an abuser. They don't have to be, but we've seen plenty of times that U.S. citizens can kind of coerce or force undocumented family members into doing certain actions, might be abusive towards them because they're holding their status over their heads. And so that's something to be very considerate of and understand that, again, being undocumented makes you a very vulnerable population. And even family members who might have status could be using that against you. So as I put here, the best interests of the child are the most important factors in determining legal custody, and the immigration status of the parent is not the main concern. Undocumented immigrants are entitled to the protections of the federal Constitution's Due Process and Equal Protection Clause. So denying custody based solely on a parent's immigration status is a violation of these clauses, okay? Which is why I was saying it might be something that comes up, but the law cannot require them to be a U.S. citizen or have status here, okay? And as I mentioned, the undocumented or immigrant parent could be a victim of abuse, of domestic violence. Being undocumented does not mean that they will never have status. Could mean that they are trying to adjust. So the term undocumented or the fact that they are currently undocumented does not necessarily tell us a lot, and you definitely would have to get more information about the family situation, about their status, about where they are in the process of obtaining status.
Would the parent's status have any bearing on what benefits the child may be able to get? Because that does have bearing.
So thankfully, most children, despite their status, are afforded some benefits in the U.S. They're kind of exempt from a lot of these things that I've talked about before about benefits. Usually only applies to adults. So not necessarily. It's fine that they're juveniles because they could get Medicaid for children. They might be able to get certain SNAP benefits specifically for the child. Now, it's a very weird environment to be in when a child might be eligible for some, but a parent is not, because you also don't want to harm the parent if somehow they all are receiving as a family, because that could go against the parent's status as well. Benefits are a little bit complicated, and it really just depends on the situation. That's why I would refer you back to that resource about who qualifies for what, how you might qualify. It's a great resource, but it is becoming a more complicated issue because of the new public charge rules. But a lot of juvenile children, even if they're, a lot of juveniles, even if they don't have status here, can still get certain benefits despite what the parent's status might be. Okay.
So just to clarify, so public charge really applies to adults, not children?
Yeah, so they start applying it as soon as you hit 18.
Okay.
Mm-hmm.
But did I hear you just say that even if they are eligible, their eligibility in getting those services could count against what their parents are then eligible for as immigrant status? So it's a real double-edged sword.
Exactly. And it is something that I, again, would encourage you, if you have this weird situation going on, maybe talk to an immigration attorney, because it might be that the parent will seek status in a way that even if they receive benefits, it won't harm them. But it might be not that simple. With this new public charge rule, we're still learning. It just went into effect on February 24th. There's some new forms, there's some new information that the government requests when you file for certain benefits. But we do know a lot of benefits are covered. Thankfully, the benefits that are not include WIC and Medicaid for pregnant women. So even if you might otherwise be harmed by receiving benefits, those benefits are not counted, thankfully, because it's still protecting women with young children, and pregnant women. So definitely in these situations, it's something that I would ask you to talk to an immigration attorney about, because they should be informed on the public charge issue and be able to try to navigate this very complicated system now. Okay? All right. So just to return to the immigration status and custody cases, there are some bad examples of utilizing immigration status in determining custody. I've listed 3 here. In 2011, parents' ICE detention, which forced her to separate from her child, qualified as abandonment and thus justified the termination of her parental rights, even though she clearly had no way of getting out of detention. Not.
What state was that?
Honestly, I do not know off the top of my head.
Possible.
Yeah.
That just boggles my mind. That's so awful.
Yeah. There was another case where an undocumented mother was considered unfit because either she embarked on an unauthorized trip to the United States with a newborn premature infant, or gave birth to the premature infant in the United States after entering the country illegally. It's actually shocking how often this works against immigrants, even in immigration proceedings, that even though you are fleeing with your family to protect them, that the actual act of fleeing is bad, that you are now a horrible parent because you put them on this perilous journey to get here to safety, but all of these things could have happened on the way. This does work against people even in immigration proceedings. Really depends on your judge, unfortunately. Some judges really don't seem to understand the grasp of why people flee, why a family gets to a certain point that there is no other option. So we're constantly trying to inform people on what are the factors that are pushing people away from these countries, and why it's so bad that someone would risk the health and well-being of not just the child, but the whole family to seek safety. So this still can work against people. And in 2005, an immigrant mother's daughter was removed for neglect because the mother did not speak English. So this happens.
What country
Yeah.
are we? What
Yeah.
country?
It's Missouri.
I'm sorry?
First case.
Missouri, thank you. Yeah, so unfortunately, immigration status and just the choices you make as an immigrant, especially as an immigrant fleeing violence, can still have severe impacts on what happens when you reach the country. And again, not to go over this too many times, but with the current administration, they are attacking these forms of relief, these benefits, and so especially in this day and age, it is very possible that things like this will continue to happen unless we advocate for otherwise, okay? Any questions? Sorry. Oh, okay. So again, to reiterate, terminating parental rights due purely to immigration status is never in the best interest of the child. You always need more information because you don't know necessarily the relationship and the environment that person is in solely based on the immigration status of the parent. And again, especially in this divisive time, don't let political biases or your politics themselves impact that determination. Always try to get over that and look specifically at the situation the child is living in and what's best and what's safest and what's most stable for that individual child. Okay? And that's for both immigrant children who migrated here and even US-born children, that maybe their parents are undocumented, but now they're US-born. You just need more information always. And again, the reason I am overstating this at this point is that the impact of terminating parental rights can have severe impacts on, no matter who you are, no matter what immigration status you have, it's always going to have severe impact on that juvenile and the family unit. So remember that this is not a decision to take lightly, and so we can't just be looking at the surface level of what's best for the child. Because you remember, you are taking them from maybe somebody, the only person they know as family in this country. And also, there are a lot of traumatic and social impacts on the child when issues like this come up. Okay. Which brings us to special immigrant juvenile status. So this is a little bit different. Again, as I mentioned before, special immigrant juvenile status is specifically for children who either have no parents in the country or only have one parent in the country. And there is a custody determination based on abuse, neglect, or abandonment by either both or one parent. To give you a little bit of background, still to this day, the vast majority of special immigrant juvenile status is granted to individuals from what's called the Northern Triangle. That is Honduras, El Salvador, and Guatemala. Historically, these countries have suffered a lot of violence and now are very corrupt. There's a lot of criminal gang activity, both local and multinational. So children are already, from these countries, are already probably fleeing some pretty traumatic experiences, maybe escaping forced servitude towards a criminal gang, a number of different issues. And historically, we had large numbers of unaccompanied minors from these countries, meaning they traveled by themselves, maybe with a sibling, maybe with one parent, but especially, I want to say, 2000s to 2010s, there was a peak, maybe right after 2010s, we had a very large peak in unaccompanied minors where there were 0 parents, 0 family members, 0 adults traveling with these minors to get here. So special immigrant juvenile status, even though it's been around since 1990, it does help a lot in these cases where we have minors who are fleeing countries that aren't necessarily safe for them and may have complicated relationships with their parents. And then I also put the legal justification why we have this relief where it's actually under our law. So the first step for special immigrant juvenile status is seeking a predicate order from the juvenile court, again, based on the fact that one or both parents cannot reunify with the child based on abuse, neglect, or abandonment. This part really does have a lot to do with state law. As I mentioned earlier, even though state courts and state law don't have any true immigration decision-making power, they can still make decisions that impact the day-to-day living of immigrants, and this is just one of those examples. So the findings of fact that the juvenile court has to find that they are declared a dependent on a juvenile court or placed in custody of a state agency. Child's reunification, again, with one or both parents is not possible due to abuse, neglect, or abandonment, and it is in the best interest of the child to not return to their country of origin. As I mentioned, it really just depends on the state that you're in. Both juvenile custody courts and delinquency courts can make these findings, and other courts with juvenile jurisdiction can also make these determinations. Really, it's just dependent on what state you're in. And the juvenile court must retain jurisdiction until the juvenile receives the special immigrant juvenile status. So, as I mentioned, the juvenile court plays the first role throughout this process, but then after you get the predicate order, you then apply to U.S. Citizenship and Immigration Services for the special immigrant juvenile visa, which is a temporary status that you have to remain on until you are eligible to adjust to a permanent resident or a green card holder. Just so you know, I looked it up just this morning. These cases, if you were, let's say you had just been given special immigrant juvenile status in March of 2020, you have an over 2-year wait before you could even try to apply for a green card. For people from Mexico, and if you're from El Salvador, Honduras, or Guatemala, you're over 3 years waiting for that green card. So it can be a very long wait, which is why it's very important that the custody is ordered in favor of maybe a family member if they're here, or with a state agency if necessary, to place them into a safe home while they're awaiting determinations of their status. Okay?
Is that long wait just because of numbers, or is it's not a purposeful long wait?
Well, I guess it depends on how you look at purposeful. Visas to the U.S., and when you apply for a green card in the U.S., it's visa eligibility is how we talk about it. You are afforded, 6 It's EB4 category under business visas, which is very strange. It's honestly just the category for special immigrant visas. So each year, we dole out a number of visas to each certain specific category. Some are based on family petitions, some are based on business petitions, some are in these weird categories of special immigrant visas, and they get soaked up very quickly. So these wait times occur when people have been waiting so long, they soaked up all that year's visas, you have to now wait another year before the next batch comes up. And these visa categories, the number of visas can be changed. So it's possible that these wait times can get longer. Really just depends on the number of visas given to each category and the number of extra visas from a category that maybe was not used up in that year that are then given to other categories. It's a little bit complicated, but not technically purposeful unless you look at why we only ask for so many visas for each category. So, and just so you know, delinquency is not a bar to special immigrant juvenile status. Again, most delinquency issues do not impact your immigration status directly. Just something to keep in mind.
So even if it's a felony?
That's different. Yeah, so most definitely can still have an impact, though. It really just depends on what the benefit you're applying for, where you're at through the process, that sort of thing. That's why when you do have a juvenile record, even though in most cases it's probably fine, it's still best to talk one-on-one with an immigration attorney specifically about that case to see what the impact could be. Okay? That brings us to some delinquency issues. In particular, I'm going to talk about Padilla v. Kentucky. It's a very prominent case in immigration law. Basically, the outcome of that case is deportation is a penalty, not a collateral consequence of other criminal issues. Therefore, the Sixth Amendment right to counsel does require immigration advice when an immigrant is charged and convicted of a crime. Non-advice is ineffective assistance of counsel. This is very important because going forward, if they do not get the correct immigration advice through these proceedings, it could mean that they can overturn these convictions and seek other options through the immigration system that they otherwise would be barred from. Like I mentioned, juvenile adjudications are not convictions, but may trigger conduct-related grounds of inadmissibility or removability. Really, that's why I go to, it's very case by case, really depends on what it was and what they're applying for. Juvenile court attorneys and staff may have cases that will be bound over to adult court and may have to advise non-citizens accordingly. This is very important because even though juvenile court records are different and treated differently under immigration law, adult records are not. Adult records are very harmful, so something to keep in mind. Bottom line, juvenile court determinations can cause deportation or prevent a juvenile from being able to obtain lawful status, which is why they should always know their rights while going through these proceedings and should always be in contact with an immigration attorney to make sure that they are protecting their immigration status or options going forward. So even though some cases they might be fine, there are definitely others with longer consequences that they should be concerned about. So, some notes. This is particularly related to defense counsel. Padilla does require more than just a broad warning. I put some examples up here like will result in deportation, may result. The standard is higher. Adequate legal representation as defined by professional conduct standards. So not only avoiding deportation, but also preserving avenues to lawful status. It is very important. That's why I always encourage any defense attorney working with an immigrant to always reach out to an immigration professional, an immigration attorney, for advice on whether their strategy will work or whether it will have lasting consequences on their immigration status, because it might seem expedient at the time, maybe the better outcome in relation to the criminal proceedings, but it could be very harmful later for immigration proceedings. And for prosecutors, Padilla does suggest that immigration consequences can be a tool in plea bargaining. And it should be. It should be something that prosecutors and defense counsel understand that you might be only charging them and convicting them under one crime that has a certain set of punishment doled out to it, but it could have other consequences that you have no control over. So you should be aware of it and should be considering that when going through criminal proceedings. And then ORC 2943.031 is the on-the-record advisement that judges have to give in criminal proceedings for immigrants regarding the consequences of conviction on their immigration status. So, what to look for when working with delinquency cases? Is the juvenile in lawful immigration status? In what status? Because again, depending on the case, certain convictions or conduct determinations could have severe consequences. That's why it's always important to be in contact with an immigration attorney. You also have to look at whether a conviction or determination may trigger a ground of removability or inadmissibility. Again, this is one of those things where maybe immediately you're not placed in removal proceedings, but does it make you, it doesn't make it impossible to get a green card later. And that's something you also should be concerned about. So again, consult with an immigration attorney if you are concerned about this. And then if there is no way to get around a plea or conviction that could have adverse immigration consequences, you always, always, always have to advise the client of that and have them talk to an immigration lawyer, because there might be something else that we can preserve, even knowing that there's going to be this conviction that's going to impact their status. So it's always about trying to keep open as many options and avenues as possible when going through these proceedings. And then general advice. Again, not sure exactly who my audience is, so not all of this might apply to you. But for prosecutors, when working on delinquency issues, just be willing to work with defense counsel. Again, you may be charging one crime, but it could cause much more serious consequences. Again, deportation is a very serious consequence, and even though you might not be thinking of that, it could happen, and that's not okay, especially if the crime itself should not rise to that level. Immigration courts don't care. Could still happen. And defense counsel, be aware of your client's immigration status, and always, always, always talk with an immigration attorney if you are not sure the outcomes or the impact of this case on your client's immigration status. For court staff, non-citizens may ask questions about the effects of what is happening to them, especially in juvenile court, either to the individual themselves, the juvenile, maybe to the family as a whole. Just refer them out when you can if you don't know how to answer those questions, especially if it's something having to do with their immigration status. Connect them with us, connect them with Asia, start somewhere with a nonprofit. Usually we can talk to them and kind of get them informed on what's going on, what to expect going forward. And then social workers, also be aware of the client's immigration status. And especially for you, you're probably going to be seeing a lot that other individuals might not get to see from that client. So you might be able to see issues of trafficked youth, issues of mental health concerns and how that's going to impact their case. And so you're in the perfect place to try to connect them with resources that others might not even know they need, okay? And most importantly, again, just to reiterate, it is a non-citizen's right to understand immigration consequences of a plea or a conviction, and if someone is not advised correctly, that is a violation of the Sixth Amendment of the United States Constitution. If you think someone has been uninformed or advised incorrectly, please consult with an immigration attorney. This could open up avenues to them to overturn convictions and access new options for their immigration status. We often work, both Ebenezer and I, often take calls, advise defense counsel to pursue the right avenues through court proceedings, to pursue ineffective assistance of counsel claims, and to try to protect and restore the rights of non-citizens in our country. So don't be afraid to reach out to us. We're happy to have these conversations and happy to try to get you the information you need to best assist your client. And that's it. Questions?